An encumbrance is a third person's right to or interest in land that diminishes the land's value. A deed incorrectly stated that a property was free from encumbrances, so three parties were tied in knots in Leach versus Gunnarsson. Clifford and Wilma Leach owned a parcel of land with a spring. Clifford and Wilma sold an adjoining parcel to relatives, Henry and Betty Leach. Henry and Betty received verbal permission to draw water from the spring. Henry and Betty built a dam, installed a storage tank, and ran a pipe from the spring to their property. Years later, Clifford and Wilma sold their parcel to Uva and Inga Gunnarsson. The deeds form tracked Oregon's statutory form for warranty deeds. Also, the deed included a covenant stating the property was free and clear of all encumbrances. Henry and Betty sued Uva and Inga, seeking a decree that they could continue to use the water. Uva and Inga brought a third-party complaint against Clifford and Wilma, citing the covenant. The court held 2 trials. During the first trial, the court determined that Henry and Betty owned an irrevocable license to use the spring. In the second trial, the court needed to decide whether Clifford and Wilma breached the covenant. By this time, Clifford had died. To defend against Uva and Inga's claims, Wilma argued that Uva and Inga knew about Henry and Betty's open, notorious, and visible use of the spring when they received the deed. Uva and Inga asked the judge to strike this defense, but the judge refused. At trial, Uva testified that he knew about the water use, but claimed that Clifford and Wilma said that Henry and Betty didn't have any rights to the spring. The jury found for Wilma. Uva and Inga appealed. The Oregon Court of Appeals affirmed. Uva and Inga appealed again to the Oregon Supreme Court.